My name is David Simonton. I'm a counsel with SNR Denton, based in San Francisco.
I'm Paul Glad. I'm also with SNR Denton. I'm also based in San Francisco. I'm a partner here. Both David and I have from time to time gotten involved with pro bono issues when they reach appeal as head of the appellate practice group, and David is the number one assistant in the appellate practice group. We were aware that this decision had been arrived at trial and felt that there was an opportunity to correct it on appeal.
Paul and David are really deserving of the recognition because they took on a case that was difficult. They worked very hard on an appellate brief and devoted hundreds and hundreds of hours over several years to help a 60-year-old prison inmate in Illinois.
Kinsley Hawkins is an inmate in Statesville Correctional Facility. He worked in prison industry for about 20 years.
Bit by bit, month by month, he managed to save $11,000. I mean, it's really a pretty remarkable story given how little these gentlemen make.
There has been a problem in the Department of Corrections for many, many years that when a prisoner manages to save a little bit of money, the department turns around and sues them and tries to take it all as the costs of their incarceration. That law was meant to prohibit prisoners from making a lot of money off of their crime. However, there are not many prisoners like that. So in fact, who it's mostly applied to are either people who have like a mother who dies and has a small insurance policy, or people like the man in this case who work very hard for many years and instead of spending all their money on potato chips, save it all so they'll have money for rent and clothes and all that kind of thing when they get out.
What happened, there was a complaint filed against Mr. Hawkins by the Attorney General acting on behalf of the Department of Corrections to seek reimbursement of the cost of incarceration, which were estimated at over $455,000.
Just simply stated, you have two statutes here. One is a compensation statute, which says the state can take out of prison wages the money necessary to pay for the costs of their incarceration, and a general statute that says that the state has the right to seek the assets of a prisoner to pay for the cost of incarceration. Hawkins' position was, since the state already was drawing money out of his compensation to pay for the cost of his incarceration, they shouldn't be allowed to take a second bite at the apple to tap the monies that he's accumulated. And that's exactly what the Supreme Court said.
This has been a recurring problem. Guys, particularly, and mostly they're prisoners who've been in for a long time but are getting towards the end when they get out and have saved some money. And the Supreme Court has said that if you the department can't seize money that you've been paid for the work inside prison. And that's why I think this is such an important case.
And so, to their credit, not only did they see it as something interesting, but they also saw it as press-worthy and something that the public would be interested in. Because I didn't necessarily agree. And to their credit, they really saw the importance of this case. I think that they're right, and for the work they did, and for really seeing the value of this case, they're unbelievably deserving of this recognition.
I personally like to get involved with pro bono work because I am offended by the kind of thinking that is behind decisions like this. And if people didn't get involved in pro bono work, a lot of arbitrary, unjust, abusive decisions would be made by bureaucrats.
On a personal level, I think that the one thing that I find most rewarding about pro bono work is the sense of gratification that the clients have. Obviously, these are people who cannot afford attorneys. They're in very difficult situations. Really having someone, shake your hand and say, thank you so much, this means so much to me, I think really drives home the importance and the reason why we do pro bono work.